We're back on the record. State of Utah versus Melissa Johnson-Fausett, case ending in 00142. I have Ms. McCarty here with Ms. Johnson-Fausett. I have Mr. Lewis and Ms. Thomas here for the state. Folks, we're here for sentencing. Ms. McCarty, have you had an opportunity to review the pre-sentence report with your client?
Yes.
Any additions, deletions, or corrections?
No.
I'll also note for the record, for benefit of the audience members that I have here, as well as for the state and Ms. Johnson-Fausett, I have reviewed each and every victim impact statement that has been filed. There have been some that have been duplicated in terms of how they were filed. Some were attached to the PSR, some got filed independently, some got filed more than once independently. I double and triple checked each one of those and have reviewed them in their entirety. I appreciate the thoughtful comments from each party that chose to participate. Ms. Thomas, if you'd summarize what the anticipated sentence is based on the agreement previously entered, just so that we can start and make sure there are no misunderstandings.
Judge, the agreement was 2 consecutive sentences on the first-degree felony, 5 to life, the second-degree felony with a weapons enhancement, which would enhance it from 1 to 15 to 2 to 20, and then the second-degree felony, 1 to 15.
So essentially, just to make sure that we're all on the same page, we're looking at an 8 to life.
Yes.
Understood. Ms. McCarty, is that yours and your client's understanding?
Yes.
All right, I'm going to turn the time over to you. Then I'll hear from the state and any participants that, Ms. Thomas, I believe that we indicated 2 family representatives as well as an attorney if they so chose.
Yes, Judge.
And then state's comments, and then we'll hear from Ms. Johnson-Fausett, and then Ms. McCarty, you'll have the final word. I'll turn the time over to you, ma'am.
Thank you, Your Honor. If I may remain seated here.
That's entirely up to you, as it is with all counsel.
Thank you. Your Honor, I understand the court has already reviewed extensive material regarding the offense itself, including the pre-sentence report, victim impact statements, and the mitigation report. At this stage, I simply want to make a few points that I hope will remain part of the record for future consideration by the Board of Pardons and Parole. Ms. Johnson-Fausett is not someone with a history of criminal conduct, violence, or predatory behavior. She is a 58-year-old woman with no prior criminal history, long-standing employment history, significant medical issues, and substantial documented trauma and mental health history. This offense occurred within the context of a highly volatile and emotionally charged domestic relationship spanning decades, not within the context of generalized criminal or danger to the public activity. Importantly, Ms. Johnson-Fausett has accepted responsibility for her actions, expressed genuine remorse, and acknowledged the devastating impact this has had on everyone involved, including her own son and family. I would ask the court and eventually the board to consider not only the tragedy of what occurred, but also her lack of prior criminal history, her age, her physical and mental health challenges, her documented trauma history, her strong family support, and her potential for continued treatment, rehabilitation, and safe reintegration over time. Thank you.
Ms. McCarty, thank you. Ms. Thomas, how would you like to proceed with your comments and family comments?
Judge, I would like to first ask Mr. Cameron Johnson to address the court.
Certainly. May I have Mr. Johnson come on up? Mr. Johnson, if you'd like to come to the lectern, please. Sir, thank you so much for taking the time to be here today. I'd love to hear any comments that you'd like to make.
Your Honor, thank you. First of all, I'd like to thank you and all the attorneys that are involved for all of your hard work and dedication to this case. My name is Cameron Johnson, and I am the only child of the victim, Corry Fausett, who was killed on January 6th, 2024, and the defendant, Melissa Johnson-Fausett. Due to the circumstances surrounding the events on January 6th, I have essentially lost both of my parents, and I stand here today completely alone and without any immediate family support. As an only child, my entire world revolved around my parents, whom I love very deeply. The 3 of us as a family is all I've ever known. Since my father's death, I've had to take on responsibilities for every aspect of what followed. This included managing all of his financial affairs, handling legal and administrative matters, addressing outstanding obligations, and carrying out the practical responsibilities that remained after his passing. I have done all of this entirely on my own, without any assistance from relatives or any other source of family support. I've worked continuously to ensure that everything connected to my father's legacy and estate has been handled responsibly and diligently. It has been my duty as his only child to make sure nothing has been neglected, despite the emotional, psychological, and financial strain this has placed upon me. The weight of carrying out these responsibilities alone has been overwhelming at times, but I've continued to meet them because there was no one else to do so. As an only child, the isolation has been profound. There's been no shared burden, no family to rely on, and no one to help absorb the emotional and mundane consequences of what occurred. This has left me with a deep and lasting sense of abandonment. Because so much of my energy has been devoted to managing responsibilities and simply continuing forward, I do not feel that I have truly had the opportunity to fully grieve my father's death. Much of the experience has felt surreal, as though I have been forced into a state of constant responsibility and survival mode before fully processing the reality of the loss itself. The impact of these events is permanent and life-altering. I struggle daily with the loss of both of my parents, which has fundamentally changed nearly every aspect of my life and sense of stability. I suffer from severe anxiety, PTSD, psychological trauma, chronic stress, and hypervigilance due to the blood and bullet holes I witnessed in my home after the police allowed me inside. The smells and images are permanently etched into my memory. In addition to the emotional and psychological impact, the financial strain has made even ordinary daily functioning significantly more difficult. I've had to personally manage and pay thousands of dollars for all ongoing property obligations I was forced to assume to prevent loss of the home, along with probate and legal fees to manage my father's estate and resolve legal affairs, medical bills, taxes, and biohazard cleanup bill that alone totaled out to cost $36,288 without anyone to share these burdens with. This experience has also affected my relationships and my ability to connect with others. I often feel that what I have lived through is difficult for people to fully understand, which has contributed further to my sense of isolation. I have experienced the lasting loss of my family, my sense of security, my home as a safe haven, and the foundation of life I once knew and cherished. Despite all of this, I have found strength within myself to carry on. I have been abandoned and left to navigate a permanent loss and profound absence, and I have done so with consistency, responsibility, and resilience in circumstances that I wouldn't wish upon anyone. I am determined to honor my parents' memory by facing each day with courage and hope for the future. Thank you for your time.
Mr. Fausett, a couple of comments, if you would do me that courtesy. Sir, I would never disrespect you by saying that I understood even a small portion of what you've been through, because I don't. But what I can tell you is that what you've shown me today is that impressive, amazing level of resilience. And I wanted to tell you how sorry I am for your loss, not only of your father, but of your mother, as you indicated very, very thoughtfully in your comments. And I can only wish you peace moving forward, and my hope is that this process has, by it ending today, to a certain extent, it might allow you some of that time that you've spoken so eloquently about in terms of furthering your healing. And I wanted to tell you thank you so much for being here today.
Yeah, thank you.
Thank you. Ms. Thomas?
Sabrina Smith for the family background.
Wonderful. Ms. Smith? Ms. Smith, good afternoon. My name is Judge Denise Porter. I'm happy to hear from you today.
Thank you. And Your Honor, I'm Brock Best, counsel for crime victims representatives.
Thank you so much, Mr. Best. I'll go ahead and take the photo, and then if you would like to stand with your client, you're welcome to. I'll return this when you're done speaking. The time is yours, ma'am.
Your Honor, my name is Sabrina, and I speak on behalf of my entire family. Corry was my uncle. It's been over 2 years, and yet we still struggle with how someone could take the life of a man so deeply devoted to those he loved. Corry was not perfect, but he was good. He was patient, loyal, and always showed up for his family, even when it was difficult. What happened didn't just take his life, it changed all of ours. In many ways, it feels like we've lost him twice. Years before his death, there were barriers placed between Corry and us by the defendant. We felt our time slipping away with him. We missed the normal family moments, holidays, gatherings, milestones. He was still alive, but we felt like we were losing him because his presence was limited, discouraged. Those lost years of connection are part of our grief, even before we lost him forever. Despite that, Corry still tried. He would come to family events, even under pressure. That was his quiet way of saying, I still love you. Those moments meant everything. But now there are no more. We lost him completely, and that void cannot be filled. Since his death, we have been living with a grief that does not fade. It appears in every quiet moment, in every empty chair, in every gathering where his laugh is missing. His absence has left us not only emotionally shattered, but also financially burdened. It's a weight we feel every single day. Our family also lives with a deep fear of what could happen if the defendant is released in just a few short years. That fear has added another layer of anxiety and emotional distress to an already devastating loss. Instead of feeling peace or closure, we continue to live with uncertainty and worry about the future. More than anything, though, we miss him. His laugh, his warmth, his way of making others feel important. Corry didn't deserve what happened, and we will carry his loss forever. We ask you to consider the full weight. The life that was taken, the years we lost before, and the lasting pain we live with. We cannot move on from this. We carry it every day. Thank you. Fausett family.
Ma'am, thank you so much for taking the time to be here today, for the written comments, for your thoughtful approach to this. Understand that I will say the same thing to you, that I can't possibly understand the loss you're going through, and sadly nothing that the criminal justice system can do can fix this, because we can't bring him back. But what I can do is let you know that I, along with every single person that I have the pleasure of working with, take this with the highest level of importance, and I will continue to do so. And I wish you also nothing but peace and good memories of your time with your loved one.
Thank you.
Thank you. And then counsel, let me go ahead and return this wonderful photo to you. Do you have any comments you'd like to make, sir?
Not this time.
Thank you. Ms. Thomas, state's comments.
Thank you, Judge. I'm not going to belabor a lot because the sentence is largely agreed, although I don't believe we did a Rule 11 on this case that bound you to anything. So I do want to provide an understanding of how we reached the agreement that we did. Some housekeeping to start with is that we are going to be asking for restitution for the Utah Office for Victims of Crime. Our total that we have received so far from them is $3,092.08. I'm sure it's going to be quite a bit larger, especially given Mr. Johnson's mention that he just did about the house renovation or restoration that had to happen. As well, he is in treatment, as could be expected, and would like to have restitution remain open to address those claims in the future. So I guess I would ask for that amount to be ordered at this time for the UOVC, and that it remain open. At the entry of plea in this case, I had mentioned the requirement statutory that the state put on the record that reducing the murder charge from the first degree felony to the second was in the interest of justice. I need to add a little bit more about that to the record because the interests of justice that are involved here are entirely the family's and have nothing to do with the defendant or her conduct. By which I mean that we were fully prepared to go forward to trial and had quite a bit of confidence in the outcome, but left the decision up to the family because they are the ones that suffered the impact. And as you have already acknowledged, there is no way to gauge what that impact is, especially on somebody like Cameron Johnson, who loves his mother and hates what she did, and loved his father and misses him terribly. And he is caught in that terrible schism, I guess, of where to put his loyalties. He's in a terrible position. The family had to make the decision as to whether they wanted to go to trial, relive the murder, the evidence that would have been attendant upon that, the uncertainty that accompanies a jury trial, and the potential years with a lack of finality for potential appeals. And given all those considerations, it was their determination that they wished to offer the plea and conclude the case. And so that is what we did. It had nothing to do with a belief that anything that Ms. Johnson-Fausett, nothing about her or her situation we felt mitigated what happened in this case. The evidence would have established to the judge and the jury that on January 6, 2024, you have heard some of the evidence from the preliminary hearing, but there are aspects of it that were missing that I think is important for you to be aware of at this time. That evidence was that on that date, the defendant and her husband, her longtime husband, Corry, were engaged in some kind of a dispute. There was yelling, there was unpleasantness, and we know this because Cameron heard some of it in phone calls with his mom. But what there's a singular lack of evidence of is that it involved any physical violence from the victim, Corry, to the defendant. She had claimed initially and in the 911 call that defendant was assaulting her and that he had hit her on the head with a glass or a stone orb. It's a heavy metal, or not metal, but heavy object, decorative. That is an object that would have been particularly suitable to lift fingerprints from, and there were no fingerprints of his on that object. She later claimed that it might have been the crutch that he used to hit her over the head. That's a little bit hard to envision, that he would have balanced himself and then swung this unwieldy item over himself and into her head. And it's just not very likely. And she also said at some point that she thought it might have been a glass because he was drinking alcohol that day, that he could have used a glass that he was drinking from to hit her on the head. He had no alcohol in his system at autopsy. That was another lie by the defendant. Not only that, but she was examined by police officers at the scene, paramedics at the scene, an emergency room doctor, and even a CT scan. There was absolutely no evidence of any kind of head trauma or any even light incident that had occurred with trauma to her head. Officers and paramedics are used to seeing fleeting signs of domestic violence or abuse, and they saw none of that on the defendant. They did see a mark on her scalp that the officer thought was probably more likely a freckle or a mole than a sign of injury. The CT scan was completely clean, and the ER doctor found no signs of injury. So whatever was going on in that room, I think that it is likely a jury would have found that this was not an act of self-defense, that Corry was not beating or assaulting Mrs. Johnson-Fausett. At some point during their dispute, the defendant pulled a gun and started firing. There were bullet holes in the walls and the ceiling of her room. She did hit the defendant with a bullet in his back or his side. That would have happened near or at the doorway to her bedroom as he was very apparently leaving the room, and it was at close range. That lodged in his spine. The ME would have testified that that was not an immediately fatal injury. He could have survived that injury had he gotten prompt medical attention. But once he went down because of that injury, the gun jammed. And instead of calling 911, instead of seeking help for her ultimately fatally injured husband, the defendant went and found a different gun. She made sure it was ready to fire, and she went to her husband, who at this point was on the ground. Blood spatter evidence shows that his head was 18 to 36 inches off the floor when she fired a bullet into the back of his head. That means he was either crawling away or perhaps army crawling. That wasn't enough. He then went down and she stood over him and fired 2 more shots into the side of his face. We know that because a bullet fell from his head when they lifted him to carry him out of the house, and there was damage in the floorboard from the bullet right below where his head was situated. This subterfuge wasn't done at that point with the defendant. She then returned the gun to its holster, returned the holstered gun to her purse, put the purse on a bench in her bedroom, and then covered all of it with piles of clothing and other items in an attempt to hide that gun. She then put the other gun that had jammed on the bed, and that is the one that she admitted to police having used. The defendant's comment in the PSR that she didn't remember using the second gun it's not credible. It is to the point of lack of credibility that is ludicrous. There is no way she could not have remembered all of her acts that led up to finding, using, hiding, and then lying about the presence and use of that gun. The defendant makes other claims in the PSR that are not supported by any evidence, namely that Corry Fausett was abusive. It is true, apparently, that there was an antagonistic relationship, that they fought a lot, that they were frequently not very nice to each other. But there is no evidence from any witness that he was ever physically abusive to her. Your Honor, this was a cold-blooded series of acts by the defendant and decisions that she made. This was why we could only make the offer we did to help the family get past what they needed to, but also to cause some accountability for what she decided and what she did that day. That is why we required that these counts all run consecutively. This was not self-defense. This was not mental illness. This was murder. And Melissa Johnson-Fausett's sentence must reflect that reality. Thank you, Judge.
Thank you, Ms. Thomas. Ms. Johnson-Fausett, you have the right to speak. You are not required to speak. Would you like to be heard, ma'am?
Yes, just briefly.
Time is yours.
Thank you. On January 6, 2024, I shot and killed my husband, Corry Fausett. And ever since I pulled the trigger, I've been in a horrific nightmare that I can't wake up from. I'm accountable and understand my actions cost Corry his life. The loss of Corry has impacted so many people. For me, I lost my husband, my love, my partner of 33 years, and my best friend. It also has in fact impacted my family his family, friends, and coworkers. And the most devastated has been our son, Cameron Johnson. He lost his father and his best friend, and in a way is losing me. I wish things had happened differently and that Corry would still be with us. I hope that all of those hurt can find it in their hearts to forgive me someday. I pray for this each day.
Thank you, Ms. Johnson-Fausett. Ms. McCarty, you have the final word. Please tell me how you'd like to handle the initial request for $3,092 to UOVC.
I believe we should set it for a restitution hearing.
We definitely need a
Oh.
restitution on the remainder. What about the initial $3,092 to UOVC? Do you want a hearing on everything?
I think that'd be appropriate.
Okay, we'll do that at the end of these comments. Final comments from council then.
Thank you, Your Honor. I'm Jordan Annette for the defense. I just want to first apologize for appearing late. I was conducting the competency hearing in Judge Poland's, so thank you for your patience. I'll be brief. I understand the state's comments, and as part of their role, they get to put forward their belief of how the case would have ended up, how it would have been found at trial. The truth of the matter is, we're not here on trial. My client, as she has just stated, is taking accountability for the actions that happened. No one at trial or here at any time would have said that she didn't pull a trigger and kill her husband. There are, I do believe, some disagreement on what led up to it. We did not go to trial on that. We did not put forward evidence. We did not put forward witnesses. And so I understand that where the state is coming from, that is the evidence that they would have presented. We would have presented different evidence to put forward either a claim of full or partial self-defense. Regardless, this isn't the forum where we're going to belabor that. That's not why we're here. We are again here because my client has decided to take responsibility for the actions of the fact that her husband, Corry, was killed. And so I just wanted to put that on the record. But other than that, we believe that the plea deal that was offered and that was accepted, we are in full accordance with that, and believe that the PSI does reflect a lot of the information that we wanted to put forward to the court, and would ask that the court continue to follow that as well. Thank you.
Thank you very much. Give me 1 second, everyone, please. Ms. Johnson-Fausett, I've had the opportunity to review the victim impact information. I've heard from 2 family representatives today, as well as heard from you, council, as well as the state, as well as all of the filings up until, it would have been up until about an hour ago. If there's anything that was filed within the last hour, I didn't see that. But otherwise, I've reviewed all of the documentation that has been provided in this case. I have reviewed the pre-sentence report. There were no additions, deletions, or corrections as noted on the record. Ms. McCarty, that's correct?
Correct.
And the reason, folks, that I started my comments with having Ms. Thomas essentially outline the agreement is because I have every intention of following that agreement. The agreement of Ms. Johnson-Fausett is that these sentences run consecutive. Consecutive means back to back. That means the longest possible sentence. Concurrent would mean one on top of another, and it can mean things are a little bit shorter sometimes. That is not the agreement in this case. The agreement in this case from all parties is that each and every one of these charges runs consecutively, which means back to back to back. Ms. McCarty, that is correct and as reflected in the pre-sentence report, correct?
Yes.
Ms. Thomas, that's your understanding as well?
It is, Judge.
Having reviewed the pre-sentence report, the input from AP&P, the input from all parties, as well as the aggravating and mitigating circumstances and other statutory requirements, Ms. Johnson-Fausett does in fact have a essentially absent criminal history, but Ms. Johnson-Fausett, that doesn't abrogate why we're here. We're here because you took the life of your husband and you've made an agreement that is going to keep you in prison for an incredibly long time, if not, quite frankly, for the remainder of your life. That will be out of my hands. It will be within the hands of the Utah Board of Pardons and Parole. I'm certain Ms. Annette and Ms. McCarty have gone through in great detail that process with you. Having taken into account all of the things that have been presented to me, the plea agreement that all parties have entered into is appropriate. For murder, a second-degree felony, Ms. Johnson-Fausett, you are sentenced to That's the 2 to 20?
Yes, Judge.
2 to 20 at the Utah State Prison. I will recommend credit for the time that you've served. On this booking, you've been in continuous custody since the date of offense. For felony discharge of a firearm, first-degree felony, I'm sentencing you to 5 to life at the Utah State Prison. And for obstruction of justice, a second-degree felony, 1 to 15 years at the Utah State Prison. Each and every one of these charges pursuant to the agreement, as well as based on considering the aggravating and mitigating circumstances as discussed by all counsel, are to run consecutive. That means that practically speaking, for everyone here, that is an 8 years to life sentence. The recommendation for credit time served is appropriate because that is essentially the statutory predisposition that credit will be afforded for the time that you've been in custody. That's between you and the Board of Pardons and Parole. That is a forthwith commitment, and you have 30 days in which you can appeal for any legal error. Ms. McCarty, anything else?
No, thank you, Your Honor.
We'll set a restitution here in just one moment. Ms. Thomas, anything else on behalf of the state?
No, thank you, Judge.
How long do we think we need on the restitution hearing? Does it need to be special set?
I don't believe it would be a long hearing, Judge.
Then let's go ahead and have it set at 1:30 on June 23rd in person on our regular calendar. That's 4 weeks out.
I will be out of the country.
I can handle it, Your Honor.
That sounds fine. Ms. McCarty, is that a convenient date for you as well?
Yes, that works, thank you.
We'll see everybody back on June 23rd, 1:30 in the afternoon in person. The sole issue to be discussed is restitution. Otherwise, sentence has been imposed. Thank you, everyone.
Thank you.
Ms. McCarty, Ms. Annette, anything else?
No, thank you.
Please have a good afternoon. Thank you.